Welcome, everyone. We're very excited to start our From Startup to Scale Up Strategies for Financial and Legal Success series this June. The webinars are all being presented by our LEAF consultants. That's Legal, Accounting, and Financial Services. It's a consultant program that we have funding through SSBCI for, and SBDC clients are able to set up time up to 5 hours with attorneys or financial services consultants. And we've had over 150 people go through the program so far. So we're very excited about it. And today is our first of the webinar series. I'm Heidi Edwards-Dunn, Education and Communications Director at the New Hampshire Small Business Development Center. And let me share this and we'll get started. Oh, and before we do that, I want to introduce Mike Cashin. He is our client intake specialist and will be managing our webinars from today on here. And so if you have any questions, if you post a note in the chat, he'll take care of that. So today, protecting trade secret law and confidential information. A little bit about SBDC. We do two things. We do business advising and education for entrepreneurs in New Hampshire. Our advising team works one-on-one with individual business owners, tailoring their services to your needs. You can go right onto our homepage and there's a request advising button and fill out the government form, and then Mike will make sure that you get connected with one of our advisors. We are funded through the U.S. Small Business Administration and through the state of New Hampshire. We are connected to the university system through Paul College. Our clients, we're very proud of them. We're very proud of our work. We do a lot we work with a lot of clients every year. In 2024, we had a $254.6 million impact on the state of New Hampshire from all that our clients are doing. We met with almost 2,000 clients last year for advising. These are some of our programs. The e-courses is something that we have on our website and are available 24/7. You are welcome to take advantage of those and lots of other cool things. If you have any questions, I'm happy to answer them. All right. And now I'd like to introduce Amy Cann, our speaker for today. Attorney Amy Cann blends legal expertise, business insight, and empathy to deliver practical guidance during challenging times. She holds a law degree from the University of Maine School of Law, an MBA, and certifications in data privacy and cybersecurity, enabling her to address today's business and tech issues effectively. Amy teaches at the University of New Hampshire and Franklin Pierce School of Law and speaks nationally on business, employment, consumer, and technology topics. She is active in professional organizations and committed to social responsibility through pro bono work with 603 Legal Aid and support for local animal and wildlife rescues. Outside of work, she enjoys hiking, soccer, traveling, reading, and the beach. Thank you, Amy. I want to remind everyone we'd love to have your cameras on so that Amy has somebody to respond to. And if you have questions, if you put them in the chat, Mike will make sure that they get asked, or there'll be a Q&A at the end. Okay, thank you.
Yep, thanks, Heidi. So I included 4 examples here that show you the problems that arise if you don't protect your trade secrets. And we'll talk about what trade secrets are and then what you can do. But I wanted to just share why it's important. So here's an example here. A company, Smash Franchise Partners, they held Zoom calls to reach people and to get potential franchisees on board. And what they did, though, was unfortunately, they shared, I'm going to see if there's a pointer. Yeah. So they shared it with this guy, Todd. He pretended to be interested and he attended their Zoom meeting. And what he did is he took detailed notes of everything happening. And then he started a competing business. So Smash went to an attorney, they went to court, they sought an injunction to stop Todd from, stealing their business ideas and being, a competitor like that. Unfortunately, the court ruled that Smash had not taken reasonable steps to protect their trade secrets. And that's something that's critically important. It's a necessary element of trade secret law. So we'll talk about that as we go. Some of the issues where they used the same Zoom meeting code for all calls. They didn't require passwords. So anyone could have obtained that Zoom link and attended there without even Smash really realizing who they were. They also didn't use the waiting rooms to screen people, again, to make sure they weren't letting people in. If all of you recall, back when COVID happened and Zoom was getting Zoom bombed at times, other virtual apps as well, because there was not a mechanism to stop people from getting in there. And that's, it's kind of what the court said here is, look, you didn't make any effort to keep this confidential, so you can't claim it's a trade secret. And they lost. And this is, super harmful to companies like this because, they lost their edge, they lost their confidential information, they lost their trade secret value, and they're having to now start really at a loss now. So it's one example. Manufacturing company. This is a regional manufacturer, and they kept their customer pricing, vendor discounts, and margin formulas, which is critical because wouldn't it be great if you knew exactly what your competitors were charging and what their formulas were and how they were applying discounts to vendors? That kind of secret sauce of the pricing is like very valuable. And they stored this all in this Excel file and didn't label it confidential. It was on a shared company drive with no access restrictions, so literally anyone in the company could access it. It was routinely emailed out to, they allowed sales reps to email it to themselves for convenience. That's problematic right there. And then so when a sales manager resigned, he downloaded the spreadsheet that was like widely distributed, and he joined a competitor and gave it to them. So NEM tried to sue the sales manager and the competitor because the competitor should have known that this was trade secret information and they weren't allowed to use it. But and that may work often. You can sue the person who took it and then the person who used it, who should have known it wasn't theirs to use. But unfortunately, they lost because here again, NEM had failed to take reasonable steps to protect it. So if they had gone up here and they'd had strict access restrictions, that would have been great. If they labeled it confidential, trade secret, they had policies, training for people, NDAs, confidential provisions and employment agreements, those sort of things to make it clear this was not, this was ours, it's not yours, and you can only use it specifically in your job, working for NEM. Those precautions would have made such a difference. And then the competitor, and that's something we'll talk about too, but be mindful of the fact that you can get in trouble here on the flip side of this, because if you hire someone who comes to you with information that they took from their former employer, and you have, knowledge or reason to know that it doesn't belong to you or to your new employee, and you use it anyway, then you could be violating the law and guilty of trade secret misappropriation. So we'll talk about that too, because you always want to think of both angles here. Another example, lost R&D. This is, and there's a lot of collaborative shared offices nowadays. I know when I was in law school, I used one up in Portland. Our business is, legally registered. Our legal address is at a collaborative office, OHIVE and PEAS. So I use these a lot myself, and I really never really thought about it at the time. But here's an example of this company, tech startup, ForgeBeam. They have a really interesting proprietary machine learning algorithm for analyzing medical data. The lead developer works at the shared office, right? He left the logic in his notebook and left it open on his desk in a shared space while he went out to lunch. He also, to compound the problem, he often discussed design features out loud during Zoom calls without using headphones, so others could hear the conversations. He should have been in a private room or not hearing this kind of thing. So what happens is another developer from another company sees the notebook, takes a photo of it, and later they obviously share it with their company, and later a similar product appears from that competitor. So Forge Bean again, wants to take legal action. They try to sue the other company for stealing their trade secret. But they lose because again, they fail to secure physical access. That's a component there, taking reasonable steps to protect it. So here they left it out in the open. Others could hear the conversations. They had no secrecy controls in place, and evidently this employee wasn't aware of the risk. There hadn't been training. There wasn't a policy regarding it. No one was really paying attention. But here, the court dismissed the claim because, again, an element, a key element of trade secret protection is that you take efforts to protect it. Another common example, a senior sales exec at this company had access to confidential information, and it contained contact info, sales history. Is really valuable about customers that competitors would love to have. Well, he left Technova, he joined a competitor, Fuse Tech, shared this information. So in this case, we have more of a success story. John violated his NDA that he had signed when he went to Technova, and Fusion Tech improperly used competitors' information. So in this case, Technova sued John, and this is what happens here is that often the employee who violated the agreement and then their new company are both named here for misappropriating, information that didn't belong to them, these trade secrets, and they violated there's a Federal Trade Secret Act as well, and then there's each state generally has, or I think all states do have, Uniform Trade Secret Act. The Uniform Law Commission, they develop these sets of uniform laws across the country with the effort to create consistency, and then a lot of states will adopt them. So the states have adopted the Uniform Trade Secret Act, but they usually modify them a bit. So you always want to review your own state law to see what it states, but it may be very similar, and it should be very similar to the Uniform Trade Secret Act. So in any event, you can sue under federal and state law here. The court found that they had Technova had taken reasonable measures, and they issued an injunction barring further use of the stolen data, which could be really problematic for Fuse Tech because they may have used the stolen data and then added more to it and then kind of created something of their own. And now they can't use it because some of that new product or whatever it is contains another company's trade secret information. Also, Fusion Tech was ordered to pay damages to Technova and also their legal fees, while John was personally liable for damages due to his intentional breach. It could be very expensive for John because at that point, Fusion Tech is probably not going to be paying your legal fees because now they're in a hot water themselves, potentially because of what you introduced to them. They may have pushed or persuaded you to do it, and then they're more guilty. But in any event, they're going to be protecting themselves, have their own attorney. So probably John would be liable for his own legal fees and certainly the damages incurred. So I wanted to show you, I always believe it's better to learn from the mistakes of others. So think about these scenarios because these are real situations that could occur, and they, so much damage can arise from these mistakes that others have done. So what we're talking about really here is, is trade secrets, and there's several laws. There again, as I mentioned, the federal trade secret law, and here's how it defines trade secrets. It's all forms and types and so on. And then we have the state. Each state has their own variation of that. And New Hampshire is a little more simple, just as information, right? And so that could be up to interpretation. What I want to emphasize here too is that this is also referring to what hasn't worked. So if you spent 4 years developing a product, you have a lot of information about what didn't work, right? Like Edison, any famous scientist, there was a lot of time of failure, and that failure is also a trade secret. So make sure you protect that as well, because that failure, you spent money and time, and that's a valuable trade secret because you know what doesn't work. Now versus a competitor coming in there, they can access to what didn't work for you. They can save so much time and money, and now they can kind of jump off your hard work of learning what didn't work, and they can avoid those mistakes and avoid all the time and expense. So keep in mind, keeping especially in engineering, R&D, and medical, other fields where you've tried and failed a zillion times, that's also trade secret information. So keep that in mind when you're thinking about what we're talking about here in the broad picture. It's not just what's worked and what you're using now, but it's also your failures that could really benefit another company understanding, what happened. So the legal elements of a trade secret, it has to be information that's has independent economic value from not being known. So you can't have a trade secret that other people know about, because there's no value in that. It has to be not readily discernible through proper means like reverse engineering. Like if I can figure out what Heidi did, and I just kind of take Heidi's product and then reverse engineer it back, that's not going to be protected in this scenario. There are, like, if it's a patent, that's different. I know reverse discrimination. I used to do employment law. Reverse engineering has some prohibitions under trade secret law. I don't work in IP in that area; it's just more specialized. But I know there's some exemptions there, but not in trade secret. In trade secret law, you can reverse engineer something. So if someone can easily do that, that's not going to be a trade secret. But the one that people most often fail here as an element is that they have failed to take reasonable measures. And that's those other scenarios we looked at there, where companies had a trade secret. It checked off, maybe, these were done, but they failed here. And the court's not going to allow you to push through anything that doesn't meet all three elements. So what we're talking about is misappropriation. That's where the harm comes in. And that's the unauthorized use or disclosure. So disclosing a trade secret without consent for the person who actually owns it. And there's a couple of different ways that can be done. It could be improperly used to acquire knowledge. We see a lot of espionage situations, and some of you may be familiar with economic espionage. That was really the initial law that was in place for many years, because what was happening is foreign countries or people sent to try to make a foreign country happy were stealing U.S. companies' secrets and then bringing them to China, or you name it, whatever country. And that's economic espionage, and that's actually criminal too, because if it's being used to benefit a foreign country, even indirectly. But that's not what we're talking about, today. The espionage that you see happen nowadays really is just Mike goes to Heidi's company, and Mike steals information. He pretends to be comes in as a new employee, right? He pretends to be, working for the company, but really he's taking their confidential information, trade secrets, and then he's sharing it with his regular company, who he's working, undercover for. And there's a big case in the news right now too, between a couple warring global HR firms, where they're accusing each other of espionage. They sent someone in there as a spy, and that really happens. And because this is, like, we're talking about millions and millions of dollars, sometimes even more, and there's a lot of money at stake here. So sometimes it's a spy, sometimes it's actually it's stolen. Other times it's misrepresentation, like you're pretending to be a vendor, whoever, a potential customer, or it's a breach of duty. Where, again, pick on Heidi and Mike. Heidi came to my company, she signed an NDA, or more commonly a confidentiality provision in an employment agreement. By the way, she signed something saying she wouldn't share my information, and then she did. So she breached her duty, like the guy, John, that got stuck later on with a bunch of legal fees and damages. So that's kind of some examples of how something may be personally improperly acquired. And then companies get in trouble here, where they knew or should have known at the time of use or disclosure that it came from someone who either breached their duty or had obtained it through improper means. So that's common, where you hire an employee and suddenly they have these really valuable customer lists, and that that's confidential for your company, and you should know it's confidential for your competitor, but yet you don't worry about that, you use it anyway. And that's where companies get in trouble. It's really important to vet your new employees, to let them know that you don't want them to bring over anything that doesn't belong to them, and you're not going to use it. You have to be really careful, because you could end up being in the middle of a lawsuit that would be very expensive and bad reputationally if you're not careful with that. So and then of course the third scenario could be really where you learned of it by accident. I sent you an email by mistake. I sent it to Mike and I meant to send it to Susan. And now Mike knew or should have known that it was protected, right? And then he used it anyway. There is an exception there if Mike doesn't know that it's a trade secret, he uses it there, he's going to have to argue that in court. that he's not liable because he had no way of knowing it was a trade secret. But typically people know if it wasn't intended for them, they know it doesn't belong to them and they use it anyway. That puts them at risk of misappropriation. So if there's any questions, we can certainly answer them as we go, or we can do them at the end. You can always email me later if you have a quick question as well. So I know this is just kind of issue spotting, and then you can look into it more. But I kind of want to get this on your radar now. We only have so much time to run through this too. But again, happy to stop with any questions. So, what do you do? And again, this is the complication here, is maintaining that confidentiality. So how do you go about doing that? So physical and digital access controls, locked file rooms, a clean desk policy where people just can't leave their stuff laying around there, because you have, cleaners, maintenance, who could be vendors, not even, part of your company, come in there. Could be a visitor that walks by and sees the CEO's office doors wide open, a bunch of desk papers on their desk, and they pop in there and take a picture. And those sorts of things are what we're talking about. So having, a policy around a clean desk, which means that everything's put off and stored properly and locked. That's important. And if you have a room, not so common nowadays, but if you have a room or in your server rooms, those should be locked or have some sort of code for entry so that anyone can't just randomly do it. You think, well, gee, someone's going to be that bold, but they will. If they're getting a healthy paycheck to come in there and spy on you, they will definitely be that bold. And they may be creative about it too. They could dress like someone else. They could pretend to be from IT. So, you don't want to become paranoid, but you also want to have a good, healthy sense of awareness about what could be exploited at your company. Password protection, again, super easy. How do you go to the shared office environment there? You leave your desk on there. There's no password on there. Anyone could access it. Firewalls, of course, making sure there's no cyber criminals or intentional sabotage or espionage, coming in separately from another network or server computer. So think about those sorts of controls. That kind of gets into like a lot of cybersecurity and data privacy, which I also work in. So it's kind of a similar concept, but it's important. You can't play it loosey-goosey. It's going to get you in trouble at some point, whether it's a cyber criminal or it's a spy or just a motivated employee who's not happy with you anymore and wants to take your information and start their own business, or sell it to someone else or take it to a new employer. Confidentiality agreements, NDAs, those are really important. I have a client that has a really unique product they've developed, and they weren't using NDAs. They were sharing with other people, and I was horrified. So you might see a one-way NDA or a mutual NDA. A mutual NDA might just mean, I'm not going to share what I learned about your company. You're not going to share what you learned about my company or product, whatever it might be. That mutual NDA may be appropriate when you're considering partnerships or even customers, because they're sharing their information too, and they may feel more comfortable with a mutual NDA, so they know that you're not going to be able to share their information as well. Independent contractors, really important, and definitely with employees, whether it's a standalone confidentiality agreement, whether it's a provision in an employment agreement, or that's a separate NDA, doesn't really matter as long as you've got them locked in legally to know that what they're receiving is in the course of their work or interactions with your company is proprietary to your company, and they are not to share it without written authorization from your company, or there'll be legal repercussions there. And you can even put in there, as far as damages, legal fees, that sort of thing. And also when people go to leave your employment or the relationship ends, it's also good to remind them again about the fact that they have some legal obligations in here in place, that they have a duty to protect your information. So hopefully they're mindful of that going forward. And this is what's important when you're going to recruit people too, to protect you from being on the other end of it, where you're now accused of misappropriation, is to make sure that when you hire people that you're quizzing them about, do you have an employment agreement? Is there a non-compete? Is there a non-solicit? Are there confidentiality agreements? And make sure that you make it clear to that new employee that you do not want, and you will not accept proprietary information that belongs to another company. It's tempting because it can give you a huge edge, especially like, the mistakes and finding out what didn't work. Sometimes people think, well, that's not confidential, but it really is. Has a ton of value. I mean, you could spend 5 years and, millions of dollars trying to develop something, And that could save your competitor from going through that 5 years and millions of dollars, and they can jumpstart off what you figured out didn't work. So super important to do that. I deal with this in some different client situations where they inadvertently have used another company's information, and that's problematic, and we have to walk through that carefully. So I see that a lot. And then employee training, to make sure that you train staff on confidentiality, like that guy that was in the shared office situation there. Like, he should have been told, and he should have known that he couldn't, have an open Zoom meeting with other people hearing it, that he couldn't leave his computer, I wouldn't even leave the computer there, never mind leave it, just with password protection, because that can certainly be broken. But to not leave your notes open, don't take them with you. There should be some precautions. And frankly, if you have someone that's working with that sensitive information, they really shouldn't be in like an open shared office anyway. There's plenty of private offices you can rent in these situations, collaborative offices where they can have privacy and have a lock on it. So think about that. Independent contractors as well, there should be some training with them to understand their obligations around that. Marking sensitive information. This seems, silly or obvious, but that has been the difference sometimes in these cases where they weren't identified as confidential. So how would an employee necessarily know they're confidential? Because there's a lot of things that are good information to have, but not necessarily confidential. So make sure you're doing that. And what you can also do is you can use watermarks or digital tags on electronic files, so that that information goes with that content. For example, on a PDF, there could be a watermark that identifies the employee that had used that document or was provided that document. And then later on, if it pops up with your competitor and you go through e-discovery process, that's actually yours. And that's great evidence to show not only also that you took extra measures, beyond reasonable measures, to protect your information to satisfy the elements for trade secrets. So think about ways you can mark your information. It may just be like a stamp that you buy and you stamp the confidential, but nowadays most things are electronic. So making sure that there's a stamp on there, that watermark there, that it's confidential information is not that difficult to do. You can Google it, use ChatGPT. I like Perplexity AI. Any one of those can guide you through that process. Or if you have, obviously someone in IT or someone that's more, tech savvy, you want to delegate that to, whatever the case is. But don't overlook some of this kind of low-hanging fruit that's free or very inexpensive to do, and that can really help protect you. And then exit procedures, that kind of follows up on what I mentioned here, that when the relationship, it's a bad arrow. When the relationship ends, there's a strict reminder, and scare them a little bit, and make it emphasize that if they violate their duty, that you will sue them, and you'll sue them for everything you can sue them for, and you'll go after legal fees. So now they're looking at their own legal fees and yours if they lose, and then damages, and that should be enough to persuade someone not to share that information. I think that's really important. And also, this sometimes gets overlooked, and it's surprising, but we're all busy and there's a lot of moving parts all the time, and you just had to fire someone. This may not be top of mind, but it really needs to be, that you're revoking access to all your systems. You also should notify all the customers or anyone else the employee has had interactions with, that they're no longer an employee of your company. You don't want to specify what happened that's confidential. You don't want to go down that road and or be accused of defamation. But just a standard letter, just we're letting you know that Joe Smith is no longer on our staff. Please direct everything to this person. That's important too, that the company or the customers know who to go to next too. Sometimes you reach out and you just get like, I'm no longer with the company. Well, then what? Like, I don't even know who to reach out to now. So there's kind of a dual purpose for notifying customers, vendors, suppliers, that sort of thing, that someone's gone. But the most important part of that exit procedure really is, revoking access to the reminder, of course, of obligations, but revoking their access, because people may decide to ignore your warning to them, your threat to them, but revoking access there's no way around that. So that would be obviously to any access sites whether it's supplier sites, customers, portals, your email, of course, and think of broadly, like what do they have access to? And that really should be tracked in sort of an asset list or some sort of list to identify, like, what are we providing access to for everyone? Because you might forget something and they get in there and they can steal information from that or misuse it somehow. And then monitoring, I had a client who on the weekends called me because they got an alert that there was a download to an external hard drive at their company on like a Saturday afternoon. And they had raced over there and the person was gone. And it was actually a sales manager that had given notice. She was resigning, and long story short, she was actually going back to her former company, who was one of their competitors, and she downloaded important files onto her external hard drive. And we were able to call her on it. And again, I say threat, with some jest, but we did make it clear, significant legal repercussions if she used that information. It would be great. I don't have the tech background to understand if it's possible or not, but it would be great if that could be blocked, actually, because they got an alert that the download was happening, but they allowed the download, the system allowed the download. And I would imagine there's a way to block that download to external drives or access. I know you can access, or I know you can identify and block access to like personal computers coming into your network because the computers are identified. So think about ways you can control that information too, because it's great to tag it, that'll help after the fact, kind of like pets. Like I have rescue dogs, and I know and my cats, and I think even the cats are all have tags, right? And the vet scan it. Well, that's great after the fact, but doesn't help the dog, getting loose and lost. So same thing here. You want to think about like, okay, what can we do to flag us and make us aware that this is happening, or stop it as it's happening. Other ways you can do things are like you can flag messages that contain attachments or keywords related to confidential projects too, so that you're either on the alert that it's happening, or again, it's being blocked. So think about, and there's a zillion software companies out there that can provide this sort of service, or again, in-house IT, or outhouse IT can, an outside IT firm can assist you with these sorts of things. And the expense is likely going to be well worth it, because again, what's the saying, like a pound of prevention is worth an ounce of prevention is worth a pound of cure. Right. So think in that mindset, what can we do to provide protection so it doesn't become this mess? Now we have to sue, and inevitably it's a long process. Court cases are taking a couple of years, to get to trial. In the meantime, maybe you can get an injunction to stop them, but it's a messy. So let's think about prevention first. So exceptions to misappropriation liability, this would be like whistleblowers. So this comes up sometimes, like, well, in settlement agreements, separation agreements, there's always like disclaimers around the Trade Secret, Defend Trade Secrets Act. And this, just in general, any whistleblower employee, and that's defined as an individual that's a contractor, consultant, or employee who discloses trade secret information to government officials, attorneys, and so on, when it's being done solely to report, investigate violations. For example, unfortunately, companies have illegally dumped toxic waste. We know this. And reporting that would be protected. So even if you're sharing confidential manufacturing processes with the government, that does not violate your obligation, your duty here for confidentiality, because you're helping protect the country in this case, and you're reporting illegal activity. Contract disclosing proprietary algorithms to the Federal Trade Commission when reporting anti-competitive practices. Again, another example where that's protected activity. You could not sue that employee. You're already going to be in a mess already at this point, so you don't want to be looking for trouble, and you won't be able to sue them because, again, they're going to be have immunity from liability in these situations. So it's really important in settlement agreements or severance agreements in particular to make sure you do discuss the Defend Trade Secrets Act, have a little provision in there that notifies employees that they are immune from liability, because I won't be able to remember all the details of that, but I know there's it hurts you in court if you forget to put that down there. I think it's around extra damages, that you can't claim extra damages or something to that effect. So just kind of issue spot that. If you have a severance agreement, settlement agreement, make sure that, just flag, just write down Defend Trade Secrets Act provision and, look at the agreements you're using, make sure it's in there. If not, get an attorney to include that provision. And you can do a quick search to remind me, but for you to educate you on how that could affect you in court if you don't. I just can't remember off the top of my head. I just know that we never want to leave that exclusion out because it will prohibit the amount of damages you can get. Let's see. So confidentiality protections, and sometimes, things don't qualify as a trade secret, right? Like we talked about way back in the beginning, trade secrets have to not be readily discernible. So sometimes something is readily discernible. And if that's the case, it's not going to be a trade secret. Sometimes, things may have, and usually element one would be able to be met, that there's independent economic value from it not being generally known. So I think number two is usually the one that makes it not eligible for a trade secret, but that doesn't mean you still can't protect it appropriately. So when something does not qualify as a trade secret, you still have a right to protect it. It's still yours. And so provisions, NDAs, confidentiality provisions, whether again it's an employment agreement, even if it's at will, it doesn't matter. But there's an employment agreement that companies, will give to employees, and maybe a non-solicit provision in there that they can't, steal employees or customers for a certain period of time. And then you're always going to generally have a confidentiality provision, or if it's a standalone agreement, or if it's entitled NDA, it doesn't really matter as long as it creates a legal duty for that employee to be on notice that they are not allowed to share your confidential proprietary information. And that's something you want to keep private. So don't overlook this. And you can certainly in fact, you could ask ChatGPT right now to create a confidentiality agreement for you. And it's going to look pretty good, but it won't necessarily be state specific. It won't be state specific unless you put in there. And even then, we know AI is a fantastic resource that can get you part of the way where you need to be, but you don't want to rely on it for legal purposes. So I strongly recommend having an attorney review it. But you can certainly, get a draft that way. There's a zillion other ways you can get a good draft of confidentiality agreement. So take the time to include that in the hiring paperwork. And it's not the same thing as putting it in your handbook, because it's super important to have in your employee handbook a disclaimer that this is not a contract and that they are an at-will employee. So you can't rely on that provision in the employee handbook, because you already stated for your own benefit for other reasons that this is not a contract. So it's not going to be legally enforceable. It can certainly help you educate the employee that what's confidential, they can't do it, and they'll be fired for violating it. So it's a helpful limit practice, but it's not going to be the same thing when you try to go to court and show the judge the section in your employee handbook, because the same handbook also is a disclaimer that it's not a contract. So again, extra work initially, yes, but it's super easy to include it in new hire paperwork. Also, obviously, there's other steps. We'll look at some. I think I have it in this presentation, or maybe it's the one tomorrow. There's other documents you can use too. Again, NDA, same thing. Usually use this one more when they're not an employee and it's a vendor or a potential customer, or potentially a collaboration or partnership with another company. You want to have that. Often, they're mutual, so it's creating obligations for you as well to protect the other company's information. So again, these are just, you're looking for binding legal obligations here, and that will help protect you. It puts the person on notice what they can and cannot do, what's going to happen to them if they do it. And then also, for you, it's going to be a critical piece of paper if you want to go to court, because you've learned that they have violated it. Oh, okay. So I did include that there. So role of contracts in protecting business. We'll talk tomorrow about contract, like do's and don'ts, but I just wanted to talk briefly about some of the agreements you can use to help protect your trade secrets and your just general confidential information. There's partnership agreements. They're going to have similar mutual non-disclosure provisions in them to protect both parties. You may have asset agreements, with parent subsidiaries where certain things are protected in there, or if it's in the sale, if it's asset sale, that would be applicable. What's being kept and what's going to be confidential from both parties. Business contracts, there should always be a confidentiality provision in those. Again, confidentiality clauses, those can pop up in documents. Again, employment agreements typically is where I see them. We have the NDAs, we discussed that. Non-solicitation agreements, the courts are perfectly fine with non-solicit agreements. So I often encourage employers to consider, instead of having non-compete, you have a non-solicit, because that's not challenged by the courts. Generally, I haven't had it for any cases that it has been, because it doesn't affect the person's livelihood like a non-compete could. Non-solicit just says like, hey, like don't try to steal our employees or our customers or even vendors or contractors, for a period of time, during the term of your employment, and usually for a year after. So I think those are important too, because obviously those people are kind of like their own little mini trade secrets, right? They have knowledge, and they're still going to be, hopefully you've got them under, one of these here, but they have inherent knowledge that, that they've gained. And not to mention trying to replace, people is difficult. Losing customers, vendors is expensive. A non-interference agreement, this may be, a blanket agreement that they are not to take activity that would interfere with your business. So even if so for example, even if Heidi comes to me and wants to work with me, I'm not soliciting her, because a non-solicit is me going to her. If she comes to me anyway and says, and I have a case like this in court right now where my client ended up working for a company that she had a non-solicit agreement, and she wasn't supposed to solicit this company. Well, 6 months after she left, they solicited her, which is not in violation of her agreement, and we have proof of that. However, the other company is pursuing her for a breach of her duty. So a non-interference agreement would mean that I couldn't even take Heidi as a client, even if she solicited me. And that goes a step further, and I like that. Non-compete agreements are the ones that are have a lot of controversy, and I know California bans them. I think it's New York that has a ban coming on, and maybe it's already taken effect. Courts will shoot them down if they're overly broad. They're only supposed to protect your legitimate business purposes only, and legitimate business information. And it can't be so broad. I can't say Mike can't work for anyone in this industry that for 2 years, and usually it's a 1 year maximum, and has to be narrowly tailored to the situation. So if Mike has never worked in this particular customer space before, or he's only worked in New Hampshire, now we've got a regional or national ban for him. Those are way too restrictive, and the courts are going to shoot those down. Massachusetts has the garden leave rule too. If you're going to enforce a non-compete, you had to already be paying the person half of their pay for the period of that non-compete. People are always horrified with that. They say that's really expensive, I don't do that. Well, then let's look at some other options then, like non-solicits and non-interference agreements, NDAs, confidentiality clauses. Those can provide a lot of protection for you. And then again, as I mentioned, thinking about separation and settlement agreements, what's incorporated in those, making sure there's always a strong confidentiality clause, emphasizing in there, depending on their role, your company, the National Labor Relations Board, may not allow you to have a ban on just talking about the agreement. They may not allow a broad confidentiality, ban, but you can always protect your own confidential information. So if you didn't have an NDA before, or if you did, or confidentiality clause, with that employee, now if there's a separation and you're offering a separation agreement, or they've accused you of something, discrimination, whatever the case is, we know a lot of settlement agreements, always having confidentiality clauses in there, and provision clause, same thing, having them in there to reinforce maybe what you've already had them sign, or if you didn't get them to sign it, you're having it in there now. You can also incorporate a non-solicit in there too, and some other extra protections at that time, because it just has to be mutual exchange of consideration there. And you're giving them money in exchange, they're agreeing not to do these things. So again, trying to think about the kind of contracts you have. It doesn't take a to use revival or redoing of your contracts and all. It's just making sure you're properly protected, and also making sure that you are always caution yourself and employees to never violate someone else's confidentiality, whether it's a trade secret or just confidential information. You want to be really careful, and that can be challenging for employers, because sometimes employees may think they're helping the company, and for whatever reason they share information they got from incorrectly, improperly, took with their employer, and then they start sharing it, and you don't even know about that, and you can find yourself in potentially some trouble there. Maybe you can get out of that particular one since you didn't do it purposely or knowingly. But honestly, if Heidi comes to my company, she's got all kinds of great information we can use now. That kind of puts you on notice that, like, Heidi, where did you get this information? I had a case right now where my employee or my client's the employee who left, and they're being accused of taking information, and the information that they forwarded to their personal email address actually came from a executive that brought it with him from his former company. He actually took it from his former company. They paid for it, it was theirs, took it, which is super common. And then he came to my client's former company, and he shared it around. It was emailed around. I think at that point, even if it had been the companies, they probably didn't show the confidentiality reasonable measures properly because everyone seemed to get it. And then my client's former company is accusing him of breaching confidentiality, but they can't claim it's theirs. It wasn't theirs. It's not theirs. It came from another company they've got a case, but my client's former company does not, because it wasn't even their information. But that's just an example where it just happens so many times where employees bring information and, it doesn't belong to them. And if you use it, you can get on the hook yourself. So I know we talked about a lot, and I'm going to be quiet and see if there's any questions. And if not, I hope to also see you tomorrow at the contracts webinar.
That was awesome, first off.
And
I think that something that's interesting, and I thought about throughout the course of this kind of webinar and discussion as I was trying to prompt our attendees for questions and to engage in the chat, is that we now live in this world where we are joining various meetings and webinars, and we do have AI note takers, transcription, and then like listening devices. I actually want to give kudos to our attendees because they weren't just like popping in, confidential or really like, instances that may have happened to them that, they don't want to share publicly because this is being recorded. But could you speak to more like best practices around, all of these virtual meetings that we're on, and how to protect against just information being taken, shared, or all of these tools and things that could be taking information or documenting things? It's so quick to hop on a meeting versus say like in person where you can have people arrive, they can sign an NDA, or you can go over next steps or say, hey, phone's in this basket, you can't come in this room with your phone during the course of this meeting. What are kind of best practices today with all of these meetings and tools and things?
Yeah, that's a great question, Michael. And I'd say, first of all, you want to look at the terms of use. When you're using any sort of, which is AI, it's translating information and creating it in written form. So it's AI that's being used there. Whenever you have a third party, you always open the door to a potential data breach from their end, which can then access your information. And then obviously you've got something that employees can easily forward to their own personal email address too. If I have a file of, it's transcribed a meeting, a research planning meeting that talked about confidential information or trade secrets, and now it's in a transcript file. There's a lot of risk there because that could be, it could be stolen, so the employee may not have done anything wrong, but they had a data breach in their system and it was sitting there in one of their files and it was stolen. And maybe even said something like, meeting on, new widget. And if you're a criminal going in there, you might be looking for it, because nowadays cyber criminals are looking for more than just like, trying to, ransomware. They're also looking for, not trying to just hold your system and get money for you, but they're also looking for your system, things they can sell in different ways too. So they could be looking for confidential trade secret information. And, unfortunately, competition gets fierce in some fields where they could pay someone to do that, to break into your system and look for confidential information. If there's a nice little neat transcription file there, I think that's dangerous. So I think that it would make sense to prohibit people from doing that sort of thing. You might sometimes have an ADA accommodation where someone needs to have something transcribed, and you have to consider that because now you're in the ADA, Americans with Disabilities world with reasonable accommodations, and it's up against maybe a risk of data breach or confidentiality. So you're going to think through, like, because they're competing laws. One doesn't, blank the other one out or supersede the other law. Like just because someone has ADA accommodation doesn't mean that, will erase or supersede trade secret protection or vice versa. So I think you have to think through that. If you need an employee with accommodation, then maybe there's a better method for doing this, or maybe that file needs to be securely locked and kept in a certain spot. So yeah, I think that's a great point. That I think with the listening devices we have and all those mechanisms, I mean, yeah, that is certainly capturing confidential information, potentially trade secret information. And that's the thing, whenever the more systems you introduce to your company, the more you put yourself at risk for data loss. And that's kind of part of the risk of business, doing business, is you have to balance, like, is this so looking, I encourage you all to look at the terms of use to anything that you use, because it'll tell you what its rights are with your information. Sometimes you're licensing, like ChatGPT, a lot of the platforms, AI platforms like that, and you're licensing them to use your information if you give it to them. And so you can't come back later on and cry like, hey, you took my information. Like, well, you let us do this, right? So I guess the bottom line is nothing's for free in this world. So you're always giving something to use something, whether it's your privacy or risk of licensing or risk of loss of something. So I think that, yeah, that's a good point to be careful and consider.
We have another question that's boiling up in the chat, but in the meantime, do you have any suggestions around the cadence in which you should be updating standard operating procedures, employee handbook, other things, and presenting that and getting those acknowledged by employees on a regular basis? It does seem like the most vulnerable kind of places, the people that reside in your organization.
I think that depends on the sensitivity of your data. Some companies, if you're dealing with constant sensitive, confidential, and/or trade secret information, then you should have at least annual training. Training for new hires and annual training, or it could just be an annual, confidentiality agreement. And I'd also tack on a conflict of interest form to that too annually. I think because Mike, if you're there at a company for 5 years, 3 years, is that top of mind to you? It might not be. So having people sign again an annual acknowledgement of their obligations to confidentiality, and also reporting conflicts of interest would be important. Just like other things, like I always encourage companies to do annual, drivers motor vehicle checks too, right? So I think it's kind of annual first aid training, like it's top of mind that way. It's not realistic to do it all the time. Although if you're hiring a lot, definitely for new hires too. If you're hiring frequently, you might do it even more often. Employee handbooks, confidentiality provisions is not going to really change in that. It's not going to be legally enforceable anyway. So I don't think that would dictate changing your employee handbook or updating it so often. But making it available on like the intranet, because if sometimes people get, they might get a paper handbook and then they throw it, somewhere and they never look at it ever again. So I like having handbooks like intranet so that it's available in the company's intranet. So if you go to look at benefits or policies, whatever, maybe it's there and that's a reminder. But yeah, I think putting it in people's mind regularly is important. It doesn't necessarily need to be updated. It's more just, sending out acknowledgements to people, right, to remind them. I think that's a good technique too. And that's going to help, because I think, again, if you're trying to go to court to show you took reasonable measures and you never remind anyone again about their obligations, that may not be a helpful fact.
Got it. That was great. Elizabeth did a question regarding data. Does the location have to be protected in one central place, or can it be protected by several people in different locations, like on their computers? Could you speak more to that?
Yeah, I think there's risk of both. Really, if it's central, it's really easy for the cyber criminal to find it. If it's not centralized. I don't think that. I think it depends on. I think it's really comes back to like one of those data privacy rules around access control. Controlling access is only to need to know only, and that's where some, like, I think one of the scenarios we talked about earlier, where they had sent out the information to everyone. Did everyone really need it? So I think, I think access control, data minimization, those are important data privacy rules, concepts to minimize what's being provided to people, have proper access control. And also, I think it's really important to be tracking or monitoring the usage. Like, for example, my client now, who their company, and there's more going on, in that case, where it wasn't just they didn't no one, it's not in court yet anyway, but they weren't suing him for that. Once we were pursuing ours, they brought that up like, well, hey, you shared our confidential information, right? They knew that had been downloaded. So making sure you have monitoring methods there and you're auditing that too. I think that's the most important thing, is maybe you have 4 people with this confidential information, and then and so you've got access control, and they've only got, you know, that minimization, they only have what they need to have, sort of thing. But are you auditing, you know, what's going on? Are you monitoring that, you know, now you know that Heidi, it's always Heidi, it's always a Heidi. It's Heidi. Heidi has suddenly forwarded an email with important stuff to her personal address. That's a clue that she may be violating her legal obligations. So I think some monitoring, auditing would be the most important, regardless of where you actually store it.
Okay,
Otherwise,
great.
you'll never know. You never know if you don't monitor and audit. You'll never know if someone actually did share it, and it may not be obvious. And you maybe just never know. And you just, now the competitor seems to be a little step ahead of you, and you can't prove it was your information that they got.
That's great. We do have one more question in the chat, and then I'll turn it back over to Heidi to kind of close us out, and also remind everybody about the great series of events that we have coming up. Hopefully you'll come back for more and tell all of your friends. But there is a question from Taj in the chat. Can an organization's algorithm for personalized ads interfere with a trade secret?
I'm not trying to understand the question. Can you read it once more?
Sure, let me read it again. It's, can an organization's algorithm for personalized ads interfere with a trade secret? I think if we generalize it a little bit more, can an organization's algorithm cause issues around trade secrets?
Well, an algorithm is actually a trade secret too, itself. But I don't know if they want to come off mute and clarify that.
Yeah, Taj, maybe you want to ask the question in your words again.
Yeah, so I'm sorry about that.
No worries.
As far as like an algorithm, meaning like, let's say an organization has a specific algorithm where it shows ads that are personally related to you too much. Like, let's say, as far as your clothes, your fashion, everything gets too personalized. Can that interfere with a trade secret as far as potentially opening your own business, or can that interfere with, you know what I mean, like your business slowing down?
No, I mean, I don't think so. An algorithm is just an instruction. Yeah, the code and data and an algorithm is an instruction when it comes to AI. So your algorithm is valuable because it's a code of instructions, and that code of instructions on how to personalize ads or whatever. I mean, that's proprietary. That's generally going to be a trade secret, but that itself wouldn't affect the user receiving it or expose, you know, the code behind it. So I'm not sure I understand your question, Waller. Yeah, go ahead, Mike.
I think the question might, correct me if I'm wrong, Taj, but could it be more so around the data that it's trained on? And then with that data, it's potentially trade secrets that are then used to deliver results or something. Could that be?
I don't think that's problematic itself. I mean, all AI is trained on some data. The data, how you got that data, that could be someone else's proprietary information. Like, for example, if like Scarlett Johansson, that was an example there with OpenAI, you know, using her voice allegedly, I say that strongly, allegedly, that was her voice. In theory, if they had used her voice, that would have been a violation of her own right to publicity and her own information. So train the data, and I know like New York Times is suing OpenAI and a couple others. Maybe it's been settled by now. But they trained they trained their system on New York Times style of writing and research. So you can violate someone else's trade secret by training on data that doesn't belong to you, that you haven't properly licensed. But that's all this area I can think of here that would be problematic.
Okay.
No, that's fine.
So does that answer, Taj? Does that answer your question?
Yeah, that basically does.
Okay. Yeah, I mean, if you want to email me after and clarify, I may be missing exactly what you're asking, but happy to follow up.
No problem. Thank you.
Yes. I think the next slide actually has my information too, if I'm not mistaken. I think I have, yeah, so there's my contact information too. And you'll all get a copy of this too. So feel free to follow up if I'm not quite if I'm missing the point there.
Well, thank you so much, Amy. This has
Sure.
been eye-opening on many levels, so we appreciate it. Thank you all for coming, and as Mike said, do check out the rest of our workshops we've got coming up, and thanks for your time today.